All right, what is up, perps? Let me see if I can get myself together here and quit some stuff playing in the background. All right, what is up, perps? Trying to work on getting last assignment submitted for SDI, so I'm running a little behind. Which I mean, hell, it's one of the reasons I'm doing a stream tonight, because I'm going to be up and I've got stuff that I have to get submitted tonight. So here we is. G23, what's up? Who all we got? Let's see. Let's roll through. Got my man Fire Otter. What is up, brother? DLD got the firsties on it. What's happening, man? Sam Vanarchy, what is up, brother? Joe Morris, what's happening? Kurt, what is up, my brother? G23, what is happening? Let's see. Waffles, my man, what's up? Man against the masses. The meme lord is here. Nice to see you, brother. And Safeline, what's up, brother Safeline? So, once I get this started, we're going to look through just a... Shauna, what's happening? Taco Syndicate. There's another one. Jason, what's happening, brother man? Everybody's showing up. Nice deal. So, the plan tonight is... Jeff, what's up, Jeff? The plan tonight is we're going to listen to the oral arguments that actually came before this decision for them to actually overturn the bump stock ban. And the reason I want to listen to them is just to show people what goes on in these courts when they're having these oral arguments. The oral arguments themselves only last about an hour. And you have to realize in these oral arguments, there's no fact finding done. They can only deal with stuff that has been submitted into the record when this oral argument has happened. So there's no going back and finding any sort of other information. Everything has to be already been submitted to the record. Now we already know this is the 5th district, and we already had some other cases shot down, some other bump stock cases shot down. Yeah, dude, Sam, that freaking logo is badass, dude. Matter of fact, I'm going to try to hook it up and do a plasma cut out of it shortly. So let's see. Where am I at? I'm going to find my damn brain one of these days, guys. I might actually do it. I'm not saying it's ever going to happen, but it might. So let's see. Because I had this stuff set up earlier, and then I switched to where I was going to do the stream, and, well, things happen. Let's see. I think I had this in my downloads. Yep.
16.
Okay. So this is Cargill versus Garland. Matter of fact, I caught part of a live stream today where they were actually interviewing Cargill on that live stream, or had him call in or something. I didn't catch the whole thing. I was working on a bunch of other stuff. So yeah, dude, it's these folks, whether it's state or whether it's federal, believe it or not, unless they have this written into law, they have no right to govern or outlaw any kind of firearms attachment. The big fight with that is suppressors, which you guys all know. Suppressors are still NFA items. They're NFA items because they were actually written into the 1934 law or the criminal code at that point. So it's not like this case is going to stop that from happening or change that. As far as I know, that's already in criminal code. This wasn't a decision by the ATF to just outlaw that shit on their own, not like the regulations for bump stocks and for pistol braces. So we're going to have to work a little bit harder on that, because the whole 1934 NFA should have been gone a long time ago. It's absolutely unconstitutional. It always has been. And just because it's been unconstitutional this long, they just decide, well, hell, it's law now. No, sorry, slavery was constitutional for a long time, or said it was constitutional for a long time before people actually got together and said there's no reason that one man should own another man. So anyway, I'll tell you what, before we hit this, let me do a screen share. Should I do it before or after? We'll do it after. We'll do it after.
Cargill versus.
So let me see. Let me let this play. Give me a 5x5 if that audio is coming through.
Mr. Samp.
May it please the court, my name is Richard Samp. I'm here on behalf of the appellant, Mr. Cargill. At issue here is whether a bump stock is a machine gun as defined by federal law, a definition that has been unchanged for decades. A bump stock is a device that can be attached to semi-automatic weapons, and it's just
25.
several pieces of plastic and a little bit of rubber. It has no mechanical parts whatsoever. From 2006 until 2017, the Department of Alcohol, Tobacco, Firearms, and Explosives said that these bump stocks were not machine guns as defined by federal law. In 2018, the federal government reversed course. President Trump said he would like the ATF to rethink its position, and it complied.
I'm going to listen. I'm going to let this play. I'm going to be in the background real quick. I'm going to try to get this other assignment submitted real fast. So,
and it is now said that they are machine guns. We submit that ATF's prior definition, the long-standing one, is the correct one. The definition of machine gun is contained in 26 U.S.C. section 5845B, and that statute says, somewhat abbreviatedly, that a machine gun is a weapon that can fire more than one shot automatically by a single function of the trigger. Those two terms, as far as we're concerned, are relatively clear. The government has been coming up with new synonyms for those words from time to time, and we don't find those objectionable. But we do object to the government then jumping to the conclusion that after applying those new synonyms, that a bump stock is a machine gun. And we'd like to make 4 principal points today. First of all, we ask that the statute be read as a whole. The government continually pulls out individual words from the statute, and we think that that distorts its meaning. A single pull of a semi-automatic weapon, even one that has a bump stock attached, will result in a single shot. To produce a second shot, the shooter must do something more. That something more is considerable manipulations with both of his hands. He must push forward with his non-shooting hand. He must pull back with his shooting finger or shooting hand. And we submit that under those circumstances, producing a second shot does not occur automatically, because automatically generally means that something functions as a result of the action that is prescribed. In this case,
I'm sorry. Is this uninterrupted time?
Yeah. If I could have about 5 minutes and then go right ahead. Secondly, we think that there really is not any difference whether or not a bump stock is attached. A semi-automatic weapon can be bump fired with or without a bump stock, and yet it is well agreed that a semi-automatic weapon is not a machine gun. The mechanism is exactly the same even when a bump stock is attached, and we think that failure of the government to come up with a meaningful distinction between a semi-automatic with and without a bump stock is fatal to its current interpretation of the statute. Third, the bump stocks are readily distinguishable from automatic weapons. An automatic weapon, you can set it up on a tripod, take one finger, pull the trigger back and hold it, and it will continue firing until the weapon runs out of ammunition. On the other hand, with a bump stock attached to a semi-automatic weapon, there will not be more than one shot unless considerable action beyond just pulling the trigger occurs. Finally, we don't think the statute is ambiguous, and neither does the government. But if the court ends up deciding, as several courts of appeals have, that the statute is ambiguous, we think that under the rule of lenity, any ambiguity ought to be construed in our client's favor. The government has conceded that it lacks jurisdiction it lacks statutory authority to adopt a legislative rule, and therefore says that this is an interpretive rule. Secondly, it has waived the application of any sort of Chevron deference, so that even if this were a legislative rule, Chevron deference would not apply. Thirdly, Chevron deference, the Supreme Court has held, is inapplicable when it comes to criminal
I'm back.
And so that really, there is no need to apply Chevron deference, no call to apply it. And even if...
And see, here's the thing when we're talking about Chevron here. What's up, Warsaw? Chevron, and they say it in their ruling when they overturn this, in the opinion where they overturn this, Chevron should never be used in a criminal case. And remember, all these are criminal case, or this was a criminal case. If you got caught with a bump stock, that could be up to 10 years in prison. That is a criminal penalty that's applied to this. And they know good and well, the ATF knows good and well, that they cannot apply Chevron to these cases, but they're going to goddamn try. In the documents, it says that at least in this case, that the Justice Department refused to use Chevron, and then they kind of try to sneak it in. It's this weird kind of thing. But they know good and well they can't use Chevron in a criminal case. Yes, sir, D. F them.
If it did apply, the rule of lenity takes preference over Chevron deference. And with that, I would welcome questions from the court. One of the major points that the government likes to make is that 1934 definitions of the words automatically and function comply fully with the
what's happening?
Definitions that the government has adopted. It at one point said that a function of the trigger is the same as the pull of a trigger, and it now has changed that, and it says a function of the trigger is equivalent to a pull of the trigger plus any analogous motions. And we really have no problem with that whatsoever. They also argue that the word automatically should be defined based on 1934 definitions as being the same as self-acting or self-regulating. And again, we have no problem with that. What we do not agree with, however, is that by adding a bump stock to a semi-automatic weapon, somehow the firing sequence becomes either self-acting or self-regulating. The one function that a bump stock assists with, it assists a shooter in managing the recoil of the weapon. It is, if without a bump stock, it perhaps will not recoil in exactly the same manner every time, and it becomes more difficult to sustain bump firing without the bump stock.
Counsel, do you agree? I'm over here. Do you, the opinion of the court, the panel opinion, says in footnote 12 that Cargill does not argue that Congress cannot outlaw bump stocks. That's correct. You're not taking the position that Congress cannot outlaw bump stocks.
That is correct. And in fact, 12 states in the country have outlawed bump stocks. And that has been one of our principal points all along, is that this defining crimes like this are a legislative function, and we don't see the Second Amendment as being implicated by this case at all.
And do you concede that the Aikens accelerator is a machine gun, spring-aided, mechanical? The government says you do concede that.
I'm not an expert on the Aikens accelerator, but my impression is that yes, it is a machine gun, and the reason is that you don't need to put forward pressure on the Aikens accelerator.
And see, and what's up? Let me get a couple things. So yeah, Warsaw, man. I don't know about those hand guards. I haven't tried them yet, so I don't know what you'd have to do to try to get those things to work. And then what's up, DM? Let's see, Sam Van Arky. Yeah, that's Sam. Suppressors never should have been added to the NFA. They shouldn't be. It's unconstitutional, one, because they're a firearms attachment, but they classify them as a firearm. And then, of course, they put the tax on them. That's how and the reason that they even started with the taxes is because Congress, the federal government, has no power to regulate firearms whatsoever. Like reading through the arguments for the 1934 NFA, they flat out say that they can't go out and flat out ban something. They say that in Congress, in those hearings, Congress has no legal authority to ban any type of firearms. So they have no legal authority to go out and say, you can't manufacture this type of firearm. You can't own this type of firearm. Congress does not have that power. It is not within their purview. Congress can't even make a law that does that. That's why all of their dealings, like with the 34 NFA, it was all a taxing scheme. That's why they did it that way. When it comes to suppressors, of course, you know, they think about these things like it's some movie era. Oh, you're going to be this assassin. You got this quiet thing on your gun. It's an absolute asinine argument. It always has been. But hopefully, you know, we'll get a lot more of this stuff challenged because it is unconstitutional. And back then, it was doubly unconstitutional because it was a prohibitive tax. It's still a prohibitive tax. But even back then, it was even worse because your average machine gun cost right around $200. So you basically doubled the cost on it to be able to own it. Let's get back and listen to this more. DM Foss, what's up? I can't remember whether I said hi to you or not.
Aikens accelerator was the earliest version of a bump stock. It has an internal spring so that the recoil of a weapon is automatic. That's ours by basic physics. And then there's no need to push forward because the spring pushes it forward, and that pushing forward of the rifle causes the trigger itself to push forward, and it bumps automatically into the finger of the shooter. And so, as I understand an Aikens accelerator, it is a machine gun, and I think that the Aikens accelerator well illustrates why the bump stocks at issue here are not machine guns, because it does require, following the automatic recoil of the weapon, the shooter must push forward with the fore end of the rifle, pull back on the
Mr. Knives
on the trigger grip or the trigger ledge itself, and that is what causes the trigger.
And you're saying that has to happen each time another shot is fired? There has to be some movement by the shooter in order to affect a second, a third, and a fourth shot.
That's
Between
correct.
each shot, there has to be a movement.
That's correct. Every single shot, he must do that. Now,
He must do what?
excuse me?
Between every single shot, he must do what?
He must, when the recoil causes the gun to go back, causes his arm to go back, he must push it back forward every time. He also must pull back with this hand in order to
what's up, frag out?
allow the trigger finger to make contact with the trigger
PLA.
coming forward because of pushing forward with his hand.
Well, you say, counsel, that he has to make that movement. My understanding is this, and you're going to correct me, I have no doubt, is that basically when the shooter sets his or her stance and is making the motions forward with one hand, backwards with the other, fires the trigger, all that's necessary is for that shooter to maintain his stance or her stance. He's not doing all of this, he's just staying still, isn't he?
The shooter, it's not an easy process.
And see, there were 16 judges on this panel. Out of 16 judges, 13 judges voted to overturn this decision or overturn the ban. I'm thinking, by the way that question was asked, I'm thinking that judge who just asked a question, he was one of the 3 dissenting judges. And I haven't read the dissenting opinion on this yet. Yeah, Sam. I mean, you're 100% right. And the biggest thing was, you know, when they went to push the 1934 NFA, you couldn't, nobody was out there emailing and doing videos and informing people about it. Unless you were in Congress, it was very hard to know what the government was actually doing. A matter of fact, they got really pissy that the NRA showed up to the hearings. And they wanted to know how the NRA found out about it and all this other shit. Now, the NRA still screwed us on it, as usual, just like they've done with every other gun law that came around. But they were really pissed that the NRA or representatives from the NRA were at that hearing. People didn't know about their rights then. They didn't have a bunch of constitutional lawyers running around saying, "Hey, wait a second, you can't do this. That's against the Constitution." It just that wasn't there at the time.
A witness who.
Well, I mean, maybe that's where you're headed, but let me tell you, is there any muscular action other than maintaining the stance when the trigger is pulled the first time? Thereafter, isn't the shooter just maintaining that constant pressure both directions with the finger in that location and the firing goes on? It sounds sort of automatic.
Muscular pressure, and it is extremely tiring to maintain constantly going forward.
It's not new motion.
It's not an easy process.
Well, I'm not saying it's easy or hard, but it's not new motion every time, new physical reaction.
But still, Judge, you idiot. The definition of a machine gun does not apply to any physical action that the shooter is doing. It applies to the mechanical functioning of the firearm itself. The shooter could shoot this thing with his freaking toes holding a ham sandwich. It would not matter what the shooter does. The definition of a machine gun is in the text, and they get to that in their opinion down when we hit that. Yeah, that's exactly what the NRA stands for, Mike. Negotiating rights away, because that's all they've ever done. Every time I've read through hearings or I've seen the NRA in hearings, they're there to negotiate for their own little interests, and they don't give a damn about the overall interest of what the Second Amendment applies to and how it restrains government. It's just the way it's always been.
Other than maintaining the pressures that were there when the firing first began?
I would say that it is, to a certain extent, instinctual. It happens relatively fast, so the shooter has to train himself to be able to keep his finger, trigger finger, motionless, and to make sure that his arm can keep going like this. He's probably not thinking about it, oh, I better push it again, because it happens very, very quickly.
But does
It still requires
require a physical act by the shooter? Is that what's triggering it, or is it simply whether the trigger itself is being impacted by one thing or another? In other words, I'm not sure why the statute would require the shooter themselves to be doing something as opposed to something happening to the trigger?
The reason why it's important in our minds that the shooter has to be doing something is the word automatically. The
GOA, which I joined them a while back, the GOA spends a hell of a lot more time actually engaging in trying to fight a lot of this stuff, I think, than the NRA does. Even though the NRA has tons more money, but the NRA would rather pay for a guy to walk around in $20,000 suits instead of putting that money on suits where it mattered, as in actual litigation lawsuits.
What the statute says is you begin with a single function of the trigger. If a single function of the trigger then sets in motion an automatic process, then
I guess the point I'm trying to make is something has to happen to the trigger, whether
Sup,
it's
Ron?
shooter-oriented or some other device.
Right.
Imagine somebody invented a robot that
And
caused.
listen to this dude's analogy, because I kind of get where he's going with it, but to me it's kind of a piss poor analogy. But what's going on, Ron Wayne?
The trigger to be pulled multiple times. All the shooter has to do is one single button and it turns on the robot, but the robot is triggering it multiple times.
Right.
Is that a machine gun? I assume your answer would be no.
No, that is a machine gun, and that is what this court held in the Camp case. That in the Camp case, there was a single push of a switch or a button, and there was a motorized mechanism in the gun that then caused the trigger mechanically to, without anybody doing anything with the trigger moved back and forth by itself, and that was held correctly, in our view, to be a machine gun, because one pull of the trigger, one function of the trigger, then caused all of these things to happen. And the mere fact that the trigger continued to move, the court held was not relevant to the analysis. It was still a machine gun because it was all happening automatically.
It's the automatic firing of successive shots.
I'm sorry, I didn't hear that.
The automatic firing of successive shots, one after another.
Right,
Automatic.
right. If it's automatic, it's a machine gun.
That's not what the statute. Sorry.
I'm sorry, I didn't hear his
I'm sorry.
question.
No, I interrupted you. Go ahead.
No, go ahead.
I said that's not what the statute says. It says automatically more than one shot by a single function of the trigger. The hypothetical that you were talking about with Judge Ho sounded like multiple functions of the trigger that were activated by a button. It suggests that's a distinction, I think, that's in the text of the statute.
Okay, in that particular case, they were referring to the button as the trigger.
Well, why is that correct? The statute doesn't say a button. It says a single function of the trigger.
I would think that the word trigger has been broadly construed by a number of courts of appeals, including the Court of Appeals. Traditionally, we think of a trigger as a lever that can be pushed forward or pulled, and in those circumstances, then yes, if the shooter must do repeated functions of that trigger, or it repeatedly functions, then it is not a machine gun. But in the Camp case, the court defined a trigger to be the actual switch that you pushed, and I think that is fair to provide a relatively broad definition.
That was a
Okay.
Counsel.
I'm sorry.
You go ahead.
I'm over here. I do think there is a good argument that the focus is on the human and not others as to whether that's automatic, whether it's a machine gun, whether it's not. I'm trying to just understand, you've had this conversation with Judge Southwick. If I'm holding this rifle and I do the first shot holding down on the front, holding on the trigger, and I don't move after that, does it keep shooting or not?
It's not possible to not move, because your arm is always going to come back with the recoil. You have to then push.
Well, that's true with rifles in general.
Excuse me?
That's true with rifles in general.
That's correct.
Yeah, okay, but what I'm saying is I'm not doing this hand that's not the trigger hand. Does it have to do, you keep going like that, do I have to go like that, or can I just hold on tight?
If you held on tight and you prevented any recoil, I'm not sure that it would be an easy thing to do, but if you could do that, the gun would only fire once.
It would, so, counsel, assuming arguendo, so, I mean, there's a dispute as to whether or not it even matters whether there's human motion, whether that's required or not. But assuming arguendo that human motion is required, in order for the weapon to fire again, the shooter must apply forward pressure. It may occur quickly, but do you agree that the shooter is not maintaining stationary and trying to bulk himself up in the hypothetical that Judge Haynes was presenting?
And see, these two female judges that are on this panel that you hear from right here, at least, they're completely opposite from the last woman judge that we heard, who was, when the case was brought for her, I can't even remember which oral arguments we went through then. She was basically talking about, it was a magazine ban, an assault weapons ban for Virginia or for DC. And she was just automatically, no, guns are bad. These things are made to murder multiple people. That's why they're made. These judges are actually asking some serious questions. Yeah, with bump stocks war, I don't know how well you can aim with them. I've never fired a bump stock. They were never anything that I was really interested in. The only reason I was interested in these cases is due to the ATF writing their own regulation. That's what interested me in this. Matter of fact, this is one of the things that got me so. I was interested in gun law before this. When this hit, I really started to dig deep into gun law and processes. So this case, this bump stock case, is actually what got me really diving into the weeds on this stuff.
Instead, they are applying forward pressure. And whether that happens almost, I don't want to use the word automatically, but whether that happens very quickly and more naturally in human motion, it is the human that is moving forward.
That is correct. That is human action that is required, and I believe that human action, in addition to pulling back with the trigger hand, is what makes this not automatically. Now, I also agree that with a semi-automatic weapon, you do have to have multiple functions of the trigger, and so I agree with Judge Duncan with the point that you're making.
But the way I heard your description, it sounded like the recoil forces the arm to move in one direction or the other. In other words, a shot's fired and there's recoil, and the arm moves based on the recoil.
That's correct.
So then the shooter actually has to do something to not have what normally happens happen. Because what normally happens is there's recoil and the shooter reacts to the recoil. That's natural. That's normal. So the shooter has to do something against the norm in order to have this weapon continue firing the shots.
That's correct, and that's why this is not a machine gun. It doesn't happen automatically. Instead, he has to take these additional
But if my
actions.
arm normally goes back, unless I do something to make sure it doesn't normally go back, it's going to normally go back when I fire that first shot. And then all the shots that come after that are just going to happen.
Right.
I don't have to do anything else except the first.
If it comes back and you don't do anything else, there's only one shot. If it comes back and you're not pushing forward, that's the end of the process. You have to be pushing back this way and holding back with this arm.
Yeah, dude, Warsaw, I expect any shipping company, whether it's private or whether it's federal, like the post office, I expect these companies to actually suffer from some pretty big damn lawsuits if they go through with their plans to like confiscate gun parts and all this other shit. I expect there to be some pretty solid lawsuits with that. Because what they are actually doing is they are committing mail fraud or mail theft at that point. So, and if it's federal doing it, Well, that's a big deal because it's the federal post office stealing from their own federal agency. So it's a snake eating itself. But we'll see. And we'll see whether the Justice Department actually tries to go ahead and kick this up to the Supreme Court. I don't think they will, because they don't. Well, they pretty much know that the Supreme Court, the way the Supreme Court is right now, are going to slap them in the face if they bring this to the Supreme Court. So I expect them to hang on to this. What's up, Tech Money? So I expect them to hang on to this, and just let it sit at the circuit level. But we'll see.
Sam, since you're embracing the Camp decision that it's not a look at whether the trigger's bouncing, it's the shooter's single action or not. My question is whether, since Judge Ezra, as I understand, has military experience, he had a trial, he heard expert evidence on all these questions you're getting about exactly push, pull. Do we have any assistance from the trial record in this case?
Well, the trial record in this case, first of all, includes the administrative record, and as the government has repeatedly insisted, the administrative record is controlling in this APA case. And the ATF has thoroughly explained how the process takes place, and we really don't disagree with how it was described there. We do think that Judge Ezra made one mistake in his finding when he seemed to think that it was the recoil that caused the trigger to bump into the trigger finger.
And see, but none of that matters. It doesn't matter what the shooter's doing. And they're like, again, they list that in their opinion. It doesn't matter what the shooter's doing. A machine gun has a very specific definition in the text of the law. And again, they talk about it in their opinion. I've talked about it on my channel. There shouldn't be any gray areas in a law. And if there is a little bit of a gray area, then it should always rule on the side of the person being charged, not on the state side of the case. And these judges bear that out in their opinion. Misty, what's happening? You got that pimp hand strong? Hope so. But yeah, anytime there's a gray area, it should always fall to the people side, not the government side. And it should terrify anybody that there is any gray area in a law, especially criminal code.
Instead, the recoil separates the trigger and the trigger finger, and it is only because of pushing back this way after the recoil that the trigger and the trigger finger come together.
Did you raise that mistake anywhere until your reply brief on the en banc?
We did not directly raise it, but we think that there are enough other findings in the district court that basically contradict that finding, because the district court repeatedly said that he agreed that it required two hands to operate this, and in fact, Mr. Smith, the expert witness at trial, explicitly said,
"What's up, Sunflower?"
that it requires two hands to operate it, and he explicitly said in his testimony that the recoil separates the trigger and the trigger finger. So we were relying on all of the findings of fact. I don't think that one finding of fact is determinative, but we do think
if the Supreme Court grants cert in the pending petitions from the Sixth Circuit and the Tenth Circuit and the likely petition from the D.C. Circuit, should we proceed or should we pause?
I would suggest you would proceed. The cases that are before the court right now, first of all, they are both on a preliminary injunction stage. They are not final decisions the way this one is. Secondly, they are much more focused on the Chevron issue than this one is. Here, both the district judge and the panel said that they didn't find any ambiguity. The cert petitions, both from the Sixth Circuit and from the Tenth Circuit, point out that that Chevron deference was.
Yeah, Sam, if for the federal post office, anything that is a legal product that is safe to ship, they have to ship it. They're not a private company. They are part of the federal government. So if it's a legal product, they have to ship it. If they go through and they're opening boxes and taking legal products and destroying legal products, yes, they are breaking the law. That is a federal crime. That is a felony, especially when you look at how much money is involved in a lot of these parts. I've put in plenty of orders that were over $500 to order parts and order things for guns that I'm building. So yes, that's federal statute. And I do expect for them to see a lot of litigation on this, because especially with it, you got to think about this in kind of a whole, and it branches. It's like a freaking spider web. This court is it shouldn't even have got this far, but this court is actually setting a precedent that the government cannot manage firearms attachments. Unless it is in the strict letter of the law, then the government can't touch it. So that goes to frames and receivers. That goes to pistol braces. Frames and receivers, actual firearms, have a specific definition in law. Unfinished frames and unfinished receivers do not fit that definition. Here's another kicker, though. Neither does an AR-15 receiver. Does not fit the definition, the textual definition of a receiver. And the ATF has dropped some cases so that they didn't have to go through and let the courts rule on that. So that can get pretty interesting if we go all the way down this rabbit hole. And we actually have judges who will read the statute. This is what judges are supposed to do, and this is what pisses me off about it. The judge is supposed to read the statute and see whether that regulation or that law is against the Constitution and whether it fits inside of a certain statute. And they don't. The last few courts that have heard bump stock cases read the textual definition of a machine gun, which no bump stock fits inside of that. Neither do trigger cranks, neither do binary triggers, neither do force reset triggers. None of that fits inside the textual definition of a machine gun. And they said that they thought the FBI was using the proper reading of that statute, which is absolute horse shit. Gray areas in criminal law are ridiculous. If it is not in the exact text of the law, then it is not a goddamn crime. And if it's not in the exact text of what makes a machine gun, then it's not a machine gun. And that's what this court ruled by. At least 13 out of 16 judges did. I think that's a pretty good freaking case right there when you have 13 out of 16 judges who say that this is a bunch of horseshit. Bacon, what's happening, man? Now, this is over. This is the case that the oral arguments that led to the Sixth Circuit overturning the bump stock ban case, or the Fifth Circuit. Fifth, I think. Yeah, Fifth Circuit.
Was applied and should not have been, so that the court might well decide the cases by saying that that the lower courts improperly applied Chevron, and then they would remand for further action in the case. So I'm not sure there's any reason for a pause. We would still, at the end of the day, need a decision as to what this particular statute means.
Could you quickly address your secondary argument on lenity?
Yes, the rule of lenity is a long-standing issue longstanding canon of statutory construction, and it applies in any criminal context. The Supreme Court, in its Chevron case, said that Chevron deference only applies after all other canons of statutory interpretation are applied. And one regularly applied canon is lenity, and so therefore it ought to come before the application of Chevron. And indeed, in several recent cases, both Abramski and one other, Pell, the Supreme Court has said that Chevron should have absolutely no application in the context of criminal statute.
But it would come only if we determined there was some ambiguity contrary to what y'all are arguing.
Right. We don't believe the statute is ambiguous, and this is simply a backup argument.
No, the statute on what a machine gun is in the definition is not ambiguous whatsoever. It's there. And again, when they're talking about the rule of lenity, that means if there was any ambiguity, God, I can't say that, then that basically falls to the people and not the government. They should always err on the people's side.
Find ambiguity. Thank you very much. I'd like to reserve 5 minutes.
So this guy coming up is for the state. This guy is the state's attorney. He's the one arguing on the side of the ATF.
May it please the court, Mark Stern for the government, and I'm happy to take questions, obviously, on any concerns that the court has, but a lot of the discussion with my friend on the other side has focused on the issue of the automatic nature of the firearm. And I think I want to make clear, I'm not personally a firearms expert. However, the district court judge not only had the benefit of the administrative record, but conducted an evidentiary hearing, and ultimately, I would just suggest that where the court has, questions, that might legitimately be occurring, that record is, and the district court's conclusions about that record, would be of great assistance. But just to sort of clarify, in the sort of broad terms, the whole point of the bump stock really is to allow a shooter to fire, I'm just going to use automatically, not, in a specialized sense, just like in the sort of normal usage. That's the whole point of the bump stock. That's why you get a bump stock, is to allow you to do this. And it functions by, you don't do anything with your trigger finger after the firing is initiated. The trigger finger sits on a leg.
Again, nowhere in the textual definition of machine gun does it mention a fucking finger, you jackass. It's why this stuff should never have gotten this far. Now, I'll show you after this. We'll read through a couple things in the opinion, and we'll do it kind of quick because, I do have to be up early in the morning, but we'll do it kind of quick. Where these justices here are actually saying the same thing. It's none of that matters. The textual definition is what matters. The law, what the law says, is what actually matters. And in this case, it doesn't mention anything about the shooter's finger, nothing. If you're worried about a dude's finger, you better go find Jerry Michalak, Lena Michalak, and a bunch of other professional shooters and cut their fingers off, because they can keep up with an auto sear just pulling the trigger by themselves.
Edge, and as the district court said, you could just replace that finger with a rod, right? So it's just
whatever it is, the statute says single function of the trigger. The trigger still has to engage, right?
Yes, the trigger moves back and forth, Your Honor.
Say the finger, it says the trigger.
That's right, Your Honor. And what again, to sort of, counsel, I think, has correctly acknowledged that this court's decision in Camp addressed that and addressed it correctly, and also recognizes that the 11th Circuit properly sustained the classification of the Aikens accelerator, which also involved the trigger going back and forth. And when you look back to the sort of how
I'm trying not to, Bacon.
Being and the colloquies with the head of the National Rifle Association at the time, as well as the plain dictionary meanings at the time, what's clear is that, and here's where the word pole and function start to get used somewhat interchangeably. They're going, does it work so that you do one thing that triggers the sequence, and then after that the sequence has to be automatic. But the first question is, do you only have to do one thing? And that's what the entire discussion was sort of.
And see, here's where these idiots on the Democrat side of our federal government and in some state governments are trying to add in semi-automatic weapons into the definition of machine gun, because the definition is actually a auto loader, meaning that when you pull the trigger, the gun cycles and automatically loads another round into the chamber. They're trying to stick that and shoehorn that into the definition of machine gun and place those under NFA control. And you can bet your ass there's still going to be a couple of bills coming out in the next little while in the federal legislature that are going to do this, which again is absolutely unconstitutional. They don't have the power to do that. The only reason the 1934 NFA actually got through is because the Supreme Court at the time was under a hell of a lot of pressure, and they were under threat of, I think it was Roosevelt, going in and packing the court and diluting the makeup of that court at the time. I really believe that's the only reason that the 34 NFA was actually upheld, which is a bunch of horseshit. Again, they put that onto the Interstate Commerce Clause, and they gave a very, very broad definition of interstate commerce and what the government could do under interstate commerce. Whereas before that, the courts had always ruled on a very limited power that the government had on interstate commerce. So there were some really big changes right around 32, maybe 29 to 30 something that led to the 1934 NFA, and then led to that being upheld.
Back and forth and trying to figure out what a machine gun was. And they didn't use the word pole, which would be narrow. They used the word function. But the point that's relevant here is that that's what they're talking about, function. It's it's the function, do it once. That's it. It starts off the firing. Then you come to so is that
waffle
trigger automatic firing? So the answer there is, yeah, you're holding, and again, I'm an expert and I'm also a bad actor. So you would be holding the firearm. I mean, I have tried it, so, but I'm still not that good at it. You simply are holding it and you're pushing forward. Your trigger finger isn't doing anything other than sitting still, and you continue to maintain a continuous pressure. Does your hand does that jolt you back and forth a little bit? That arm, yes, it certainly does, but you're not sort of forcibly taking it back and forth. You're maintaining a continuous pressure. And it sort of boils down to an argument that if you have to do anything else other than press the trigger, then it can't be automatic.
Well, see, again, doesn't matter what the shooter's doing. That is not the textual definition of a machine gun. There was one time, it was a long, well, it was when it first started with the FRT stuff. I was in one of John Crump's chats, and there was a guy in there, he didn't like the FRTs. He thought they ought to be banned as machine guns. And I kept saying to him, they don't fit the technical definition of machine gun. They don't have an auto sear that controls where the hammer is in relation to where the bolt is actually moving. There's a relationship and time there and function that FRTs don't have. FRTs just force the trigger to reset. That's why they're called a force reset trigger. They don't fit the definition. Why am I so hard on this in criminal code? Because if the ATF can go out there and they can use their own definitions for things in criminal code, well, then they can throw anybody in jail for anything. They could turn around and literally say, fuck it. AR-15s, AK-47s, civilian versions, semi-automatic are machine guns anyway, because they perform automatic functions. Hey, what's up, Sunflower? No, we're just listening to some oral arguments over the bump stock case and getting over the fact, or going through the fact that if things aren't in the actual textual definition of the law, then especially in criminal code, then the government has no right to interpret that code any way they want. If it's not in the code, it doesn't matter. Write better laws, you bunch of jackasses. Pistol braces are the same way. It is a pistol brace. It's supposed to go around your arm, supposed to shoot one-handed. So what? If I use it outside of its intended purpose, so what? If you don't like bump stocks, you can't just make a regulation, a regulation that will be treated as a criminal law. You can't do that. You don't have the power to do that. Well, this is where they actually overturned the ban on bump stock sunflowers, and we're going through the reasons why all that matters and stuff like that.
Mr. Stern, don't you have to at least react once for each shot? The trigger has to shoot once. It has to move for every single bullet, and your arm has to move for every single bullet, right?
Well, I mean, I guess sort of in like physical terms, like every action has a reaction to keep it, but like it doesn't move very much. It's not like you're like maintaining that pressure all the time.
Well, did the government introduce any evidence to show that it was only a modicum of pressure, virtually no pressure, as opposed to a lot of strength or?
Well, the ATF expert, I mean, I can't remember exactly what was said, but the ATF expert, and again, this is obviously my characterizations aren't
yeah, Mike.
crucial. It's what's like in the administrative record and what was before the district court, but the ATF expert sort of like elaborated and more fully explained exactly how it works and the kind of pressure that you need to put to it. And the district court asked all the questions that are relevant to making that determination. So I just asked the court to look at that. And because, I mean, that's really, so like really, like, and it can't be conceptually that it's just if you have to do something else other than press the original trigger. I mean, even on the machine gun, you have to keep holding the trigger back for it to continue to fire.
But it's still one trigger engagement, one bullet, whereas an automatic weapon is trigger goes back and all the bullets keep going out until it's stopped.
Right, no, I agree. My only point was that, like, if you let go, I mean, and this is why, like, does the single function set off a automatic chain that keeps going until the shooter basically sort of does something to stop it, usually by releasing the pressure, and it's going to be releasing the pressure like you take your finger off the trigger in the traditional model. Here you stop exerting the forward pressure. And I'm sorry.
Well, I do have a question. I didn't know it was that obvious. I was waiting for you to finish. Mr. Stern, I have sympathy for your position, but part as much as anything that concerns me is the statute it's not talking about the trigger finger and one pull of the trigger finger. It says single function of the trigger, and some of my colleagues' questions and your friend on the other side are all talking about how the trigger has to keep being engaged. Now, the re-engagement may be automatic. I might allow you that, but it's still a re-engagement of the trigger for each firing. So we got to make that fit for your position into the sense of it still being automatic. So focusing on the statutory language that it's a single function of the trigger, how do you make that work when you have however many shots there were, there's that many pulls on the trigger?
Well, I mean, I think there are a couple of ways, Your Honor. I mean, one, D.C. Circuit in its recent, like Weddy's opinion, was focusing in part on the use of the word by. It's like what happens, it's triggered by a single function of.
And see, the D.C. circuits and all of them were trying to shoehorn this into the definition of a machine gun, but there's no way to do that. There is a definition of a machine gun. It is a pretty solid definition. Single function of the trigger, multiple rounds released, and then, and it actually excludes volley guns where you have multiple barrels and you squeeze the trigger and multiple barrels go off at one time. That's a whole nother thing. Volley guns aren't included in the definition of machine guns. But still, there's that textual definition. And bump stocks don't fit into that. And the government arguing about, oh, trigger finger doing this and shooter doing that, doesn't matter. What is the textual? This is a criminal case. What is the definition in law? What does the text say? If the text says a ham sandwich is 2 pieces of bread in actual ham, that's a ham sandwich. If you take 2 pieces of bread and you throw turkey in there and you slap it together, that's not a ham sandwich. Doesn't fit the textual definition.
The trigger, and I thought that was a useful way of looking at it. And again, if we sort of go back to think of sort of like when, the concept, that was like used was a single pull, and that's what they're interested in is, does one thing start up? And that's what this court said in Camp, where it goes, okay, there's just one, like the trigger kept going back and forth in Camp, but you only did one thing to start it. And similarly in like Flashley, the Seventh Circuit case, and for example, if you had a button that you needed to hold in like all the time, in order to keep it automatic. I mean, sort of you generally have to flip a switch to take the semi-automatic to make it automatic. But if you had to hold that switch up while you were pressing your finger back on the traditional machine gun, does that stop making it a machine gun? I think the answer is no. And Judge Gibbon, I think, was right in her 11th or 6th Circuit observation, where you go, look, that would allow, that kind of thing would allow sort of allow people just by making sort of minor additional things that you needed to do, taking a gun that was like really automatic and sort of going, well, I have to also hold in that button, so it's not automatic anymore.
Yes, that is the thing with laws. Laws should be tailored very narrowly, and if anything is outside of that law, guess what? The law doesn't cover it. We're talking about criminal law here, law that can put people in prison for decades. Whenever the state is going to take your freedom, your livelihood, your money, your time, it should be on a very narrow interpretation of the law. Otherwise, the state can just go out and literally say that if it isn't a semi-automatic firearm, well, it's performing an automatic function, so therefore, we're going to classify that as a machine gun now. Why? Well, just because we want to, because it has an automatic function. That's where that can go. But again, we have a constitution, federal constitution, that says they can't do this shit any damn way. And I'm seriously, even this last decision in the Rifle and Pistol Club, it was better than the Heller decision. I've said from the start, the Heller decisions, two of them, were a punt. They didn't go, and I think a lot of it is political. They didn't get right down to the brass tacks of the whole thing. They didn't get right down to it. They did okay, but they didn't get down to it, which is that the government has no right to regulate firearms whatsoever. And if a tax is prohibitive, then that tax is illegal. End of story. 1934 NFA can go away. They should have laid that out, but they didn't.
We don't think that comports with any understanding of automatic, and we think that we think that the agency's definition is the correct one, and its application here is correct. We think the district court decision is very careful, in which the panel made sort of extensive reference to that decision. And again, I think conceptually, I think it really is important to recognize that the inquiry just can't really turn on just does the trigger go back and forth.
Mr. Stern?
Why can't it? I'm sorry, you go ahead with your question.
I want to follow up on Judge Southwick's question. This case, like many statutory interpretation cases, comes down to what statute did Congress write. I mean, I think in one of the decisions, circuit decisions, there's a diagram of the sentence in a footnote, and I won't ask you to go through that because I didn't like diagramming sentences either. But I got two questions. The first one is the subject of this sentence. Do you agree that it is weapon? It's not shooter. So such that what we're concerned about here is the mechanism of the weapon and how it functions, and not what the shooter does.
Because whether it's fired automatic, it can fire automatically more than one shot.
Well, it's a weapon
by a single function.
A weapon which shoots automatically.
Right.
Not a shooter who does something.
No, that's
weapon
correct,
which shoots.
No, we're obviously talking about, we're not banning shooters, we're banning weapons.
Okay, great. And then the second question is the automatically part. The automatically is tied to by a single function of the trigger. So if the weapon shoots automatically by something other than a single function of a trigger, then it is not a machine gun. Do you agree with that?
No.
Why not?
I think that it has to be well, let me clarify. I think I spoke too quickly. It's not that what you don't need is simply to hold in the trigger and do nothing else. If the initial pull or function of the trigger is essential to starting it out, and that's what this court said, recognized in Kemp. And
Again, jackass, that trigger is going through multiple functions in a bump stock, or used by using a bump stock. That trigger is still going through multiple functions. It's still going through pulling, resetting, all that. It's going through multiple functions with a bump stock. The bump stock is just allowing you to basically slap the trigger in time with the reset and the pushing forward after recoil. The shooter is actually doing that. The textual definition of a machine gun mentions jack shit about what a shooter does. It is all about the mechanism that the firearm uses. This is where you get into, if you give the government the right, or a government agency the right to, well, this is the way we feel about something, that shit goes off the rails. And this can lead to people getting put in prison. There was a Marine, and I can't remember, they mentioned here, they mentioned in some other stuff, there was a Marine that got in trouble for having a bump stock. I believe it was a Marine. But he had to go through or under the UCMJ, he got prosecuted. And they went through and they found that, hey, this is not a machine gun. But he still had to go through that. He still had to take all the heat from that. People being prosecuted for these dumbass gun laws that are unconstitutional. There are people sitting in prison for those while these cases work their way up through the courts. And guess what? When those laws are finally found unconstitutional, these people that went to prison for these things are not going to get their lives back. They're not going to get their money back for all the time that they missed while they were rotting in jail, while the government defended unconstitutional laws. That's a huge thing that pisses me off with this. It's a huge thing that pisses me off with people who support laws like this, or regulations in this case like this. They're unconstitutional. They will take people and put them in cages, destroy their lives, and at the end of however many years go, okay, maybe it's unconstitutional and that law gets struck down, while people are still been in prison for it, have experienced all the things in prison, which is not a very nice place to be. Trust me. And nothing will happen to the government. Nothing will happen to the people that wrote these unconstitutional laws. Nothing will happen to the people who voted these unconstitutional laws in. Nothing will happen to judges who held up these laws, and nothing will happen to police that arrested people over these laws.
And in the Aikens classification, which is that you started with a single function, and then you go, is what happens by that single function an automatic sequence? And that's where my friend and I disagree.
But I don't understand your reliance on the Aikens accelerator, because I'm looking at the rule that the ATF wrote in the Aikens accelerator case, and it says, quote, removal and disposal of the internal spring would render the device a non-machine gun under the statutory definition. So obviously there's no internal spring here. I don't understand what the Aikens accelerator has to do with this.
I mean, what it has to do, I mean, you're absolutely right, Your Honor, that this is this is a change, right? The agency revisited that part of its conclusion. The part of that is common to the Aikens accelerator and to the bump stock here is the fact trigger continues to move back and forth in both cases. The difference is that we didn't have to maintain the same forward pressure with the Aikens accelerator. But in terms of the trigger mechanism, that's starting out, that's the same.
Can I follow up on one question that Judge Duncan and Judge Southwick have asked, which is that in camp, the court focuses on the statutory definition and says we have to look at the word trigger. It's the most important part of the text. And the court points out that there is no statutory definition of the word trigger. And a lot of these cases hinge on what is the trigger. What is the government's view of what is the trigger in a bump stock?
The trigger.
The trigger. So, and is the trigger that is manually going back and forth?
The trigger is going back and forth.
It's not the forend, the forward pressure on the forend of the gun.
The forward pressure is what you need to do to maintain the automatic sequence.
But for the government's view of the statutory definition of the single function of the trigger, we look at what everyone in the room would understand to be the trigger. That is,
in this case, yes, you would just like you begin it like that, and then you hold forward. So all it boils down to, again, is does the fact that you have to maintain the forward pressure make it like something other than a automatic?
You earlier called Judge Ezra's, I think you called it his careful opinion, and there was a finding in his opinion that all semi-automatic rifles can be bump fired without a bump stock, without a belt loop or some other device. Do you agree with that? That all semi-automatic rifles can be bump fired without a bump stock or some other device?
In general, yes. I can't attest to all bump, but yes. I mean, you can bump fire as a technique, sort of, it's, you know, it's a way of firing a gun. It's it's not, that really does not initiate an automatic
firing. Why is bump firing with a bump stock automatic, while bump firing without a bump stock is not automatic?
That's where, like, the experts do a better job than I do, but the basic idea is that when it harnesses, like, the recoil, all you really need to do is to maintain that constant forward pressure. When you're just doing it with a bump, like just bump firing, the recoil can go in any direction. You, to like maintain like pressure, like so that you have to keep like rewriting it, you have to put in like all the work that the bump stock is doing for you isn't being done. You now have to do all of that work yourself. And in a lot of, like, in various, like, firearms, can a really skilled, talented, like, shooter start to mimic what a machine gun does? I mean, there's one, like, shooter who's always sighted, who, like, sort of can take any automatic gun, and he's so good. Like, he can basically get off as many shots, sort of like as a machine gun does, just by going like that with his finger. But that doesn't mean that,
Yeah, they ask the same question and it pretty well gets the same answer every single time. But it's the thing that kills me. None of that matters. There is a textual definition of a machine gun. This is what a machine gun does. This is how a machine gun functions. It is there. And a bump stock, what the shooter does, what an attachment to a gun does, has nothing to do with machine gun. Machine guns are not just defined by it shoots fast. That's not the definition of a machine gun. It hopefully never will be.
Like firearm, like, is not a semi-automatic weapon just because, you know, that one person.
Let me ask you, am I stepping on somebody else? Didn't mean to. My colleague, Judge Willett, asked a friend on the other side about the cases pending on cert from other circuits, representing that, I'm sure accurately from his viewpoint, that they focused a lot on Chevron. Would you agree with that? Do you see a fair possibility those cases will not, both heavily soaking with Chevron deference, and that may be all the big court decides?
I mean, it's hard for me to,
is the premise right? But both of those cases are focused heavily on Chevron.
They did, and I think that it's unclear what the court would do if it took the case. In theory, maybe it would resolve the Chevron question, but then built into the decisions, those courts are saying, well, I need Chevron, like, in order to rule for the government. So the court would have to stop at sort of like, okay, I'll resolve that, but then like have it sent back. And I can't remember what the questions presented are, but if the court grants cert, and presumably we'll know that the relatively near future, we can see what questions they granted cert on, and that ought to, I think, make that point clear.
But a little more pointedly, I assume the government was asked to I haven't read the cert filings. The government was asked to respond to the petitions.
Yes.
Did the government disavow Chevron? Or did it say,
Yes.
as it's taking the position here, that the statute is plain?
Yes, it's the same position.
See, that's the funny thing in this. They're saying that they're not using Chevron deference here, which if you're not using Chevron, how can you interpret the meaning or the text of machine gun applies to a bump stock? Because there's no way you can do that logically. I could seriously put this forward to my 6-year-old daughter, read her the text of a machine gun and show her how a bump stock works, And I guarantee you, even my daughter would go, that's not a machine gun. So they're saying they're not using Chevron, but in a way they are using Chevron, is the point I'm kind of getting to there. Because they are trying to interpret the definition of machine gun in a very broad way, which, again, in a criminal context, the government should be held to a very narrow reading of the statute, extremely narrow. They can't say that, well, I'm speeding just because I thought I was going to speed, but I really didn't break the speed limit. So there has to be a very narrow definition of these things.
So the government is being consistent.
Yes.
Well, it seems to me that would be a big threshold issue that the court would have to go over before they'd get to Chevron.
It might. I mean, we've urged that if the court, we've urged with the same thing that we're urging with this court, that it should conclude that the definition is the best definition.
The ATF took the position for well over a decade that a bump stock was not a machine gun, correct?
That's correct.
Well, how do you say that statutory language that hasn't changed can be black for 10 years and then it's white?
Yes. In the textual definition of a machine gun, I don't think has changed since 1934. And this judge is asking him, hey, you said these weren't machine guns for an entire decade. And now you're going, oh, well, shit, it is a machine gun. Well, how long have they interpreted non-finished frames and receivers as not firearms? How long have they said that pistol braces were not stocks? That's where this case really falls in. Liv, what's going on, brother? So that's where this case is really working. Bacon. Yeah, Chevron's so bad I don't eat gas there anymore. That's hysterical. But yeah, this is where they're claiming Chevron, but not claiming Chevron. And it's this absolutely retarded stance that we get to interpret a statute the way we want, but we're not claiming Chevron. It's absolutely ridiculous.
Because you make a mistake. I mean, courts change their views of what a statute means. The fact that you have to do interpretive work and can make a mistake in deciding a statute doesn't mean that that there isn't a...
When was the last time ATF conceded that it made a mistake?
The Aikens accelerator. They might have done it since then. But I mean...
And see, the Aikens accelerator, as I understand it, and forgive me, I haven't looked it up, it's basically a bump stock with a spring in the stock that forced the gun forward. It made bump firing even easier than a bump stock. But still, that does not fit the textual definition of machine gun. We'll go through it quickly after this. There is a textual definition of a machine gun. I've read it before. I've read it on my channel. I've read it on streams. There's a textual definition that says what a machine gun is and how a machine gun operates. Anything outside of that is not a machine gun. Trigger cranks, where you mounted this thing to your trigger and you could sit there and turn a crank and it fired, is not a machine gun. FRTs, wide open triggers, not machine guns, because that trigger is resetting. A round is only fired on a single operation of the trigger. Binary triggers, same way. Single operation. One operation pulling it to the rear, one operation releasing it and letting it move to the front to reset. That's a single operation of the trigger with each round released. Now, we are still going to see the ATF go after force reset triggers, and the binary triggers are the next on the list for them to go after. We are still going to see that. It is still going to go to court. And any officer who pushes this any politician that pushes it, and any judge who upholds it, all should be in prison for the same amount of time that they would have put someone in prison for, because it is absolutely ridiculous. In America, this should be a simple thing that if the government charges you with a crime and you have to defend yourself against that crime, if the government loses their case, they should have to pay all of the money, not you. You should get every bit of money back that you paid for your defense, for all expenses related to your defense, for any income lost, all that. The government should have to pay that shit.
Look, in the Edelman versus Lynchburg case where the Supreme Court goes, look, I don't need to consider whether Chevron is necessary, because we agree that the agency has the best definition, and then it drops a footnote saying, by the way, that doesn't mean that it was the only permissible definition either. And all we're saying is that the court reviews de novo.
What's the standard of review here? It's not a mistake. When the ATF comes out with a criminal's, this is a criminal statute, and it said for 10 years it means one thing, and then in a rulemaking says, oh, it means another. The standard review, I don't think, for us is a mistake, is it?
No, it's the question is, what does the current...
But...
this record does present us with that Attorney General Barr giving it a hard second look after the Las Vegas massacre of 60 people, 800 injured. So we could disagree about whether they should have given a second look and whether they should reinterpret. But one thing that's always perplexed me about this case, and I was on the panel, is this issue comes up all the time in state case law, I would think, in terms of virtually every state bans machine guns. And for example, Texas uses the identical language, practically the identical language as the federal ban. Do you know of any state court that has reviewed a conviction that has adopted the mechanistic interpretation to say this is legally insufficient for a conviction, or it triggers the rule of lenity? That's the first question. But just so you know both, if you can remember, I think I'm correct that the converters that are being used now are actually moving away from bump stocks. They're these little plastic switches. Do you know of any convictions or case law that would assist us saying that new mechanistic conversion is or isn't a machine gun? Those are my two questions.
I'm not aware of any. We can, I'm happy, when we get back to Washington, I'll check with.
And see, we'll look through, before we get out of here tonight, we'll look through the definition of a machine gun. And we'll look at that, because they're talking about the Glock switches and stuff right now, and Glock switches are considered machine guns all by themselves. But I believe, and I'm throwing this out here and we'll read through it in a little bit, the definition of machine guns actually mentions parts that would make a machine, or parts that would allow for that to function multiple rounds with a single pull of the trigger, something like that. Yeah, Mike, you're right, man. That's the reason that I say a lot of times, or I'm starting to learn, I should say, that we don't have a justice system. We have a legal system. If it was a justice system, the text of the law would be all that matters. A legal system allows these little weasels to redefine words on the fly to make a statute way broader than what it should be. And that's not the way it should be. Not in any code, but especially in criminal code. It should never be a broad definition or a broad reading of a criminal statute. A criminal statute should be very, very narrow.
ATF to make sure that, and get back to the court if we find any. I'm just not, I'm not aware.
Not aware of either.
I'm not aware of either.
Federal
Right. But I will also say I have not, we have not researched that question, so I don't want to represent the fact that I don't know it, means anything other than that. Though I think I would have known, but, but I'm going to double check to make sure. I'm happy to answer any more questions. The court's been very generous with its time. And
now that the state is through with their time, then the lawyer for the plaintiff can come back up, and he's got 5 minutes for a rebuttal of the state's case. And it's weird because in criminal cases, say in Kyle Rittenhouse's case, just to use him as an example, after the defense is done, then the prosecution actually comes up, and the prosecution gets a second bite at the apple in their rebuttal to the defense's case. So this is a little bit different now that the prosecution or the lawyer on the side of the state goes. Now the lawyer on the side of the plaintiff gets to come up and do his rebuttal.
We appreciate it. Thank you very much.
Well, yeah, our legal system, everything's become so convoluted, it's not even funny. Statutes are read very broad, criminal statute, which it should never be read broad like that. But it's kind of like Clinton arguing over the definition of what is. What's the definition of is? And the only way you get to this is with people that think they're educated, but they're actually just morons, to be honest with you. If you've never seen Hank Johnson, who is a congressperson, I don't think he's a senator, he's Congress. Have you ever seen that dude talk? He has a law degree. My left toe, little toe, has more brain cells than that guy. But he got a law degree. The criminal statutes, I'll say it 1,000 times, criminal statutes should be very, very narrow. Anything outside of that criminal statute, well, it's not a workaround or anything like that. It's not a loophole. It is just not in that statute. Fifth, I plead the fifth. 1, 2, 3, 4.
Counsel for the government seemed to suggest that more than just pulling the trigger is required to make a automatic weapon continue to fire, that you need to continue to hold the trigger. And our position, as we spelled out in our brief, is that basically pulling and holding the trigger is a single action. That's essentially what the Supreme Court held in the Staples case. The ATF basically takes that same position. There is a type of trigger called a binary trigger, which if you pull the trigger, you get one shot. If you let it go, that's a second shot. ATF has consistently said that that is not a machine gun, and that is
because
100% pulling
right.
and then letting go are two separate actions. So therefore, by that reasoning, pulling and continuing to hold the trigger is only a single action. The government suggests that the finger could be replaced with a post, and nonetheless, when you're bump firing, it would continue to fire without your finger being there, and that's correct. The finger is sitting there, and it's the trigger coming forward and hitting it that causes the weapon to fire, and that would be true if it was a post or not. But what the government doesn't mention is that you must nonetheless, even with a post there, you would continue to have to push forward, you would continue to have to pull back. You might not have to contact the trigger, but you would have to have your trigger hand on the grip and pulling that back. And those actions are what mean that it is not an automatic sequence that is occurring. Furthermore, in every single one of those situations, the trigger is going to continually function multiple times. It will not be one function of the trigger, and the trigger is functioning multiple times precisely because, not because of the initial pull of the trigger as in camp, it is continuing to function because of the human actions that are taking place. There was some question about whether there have been any criminal convictions, and I'm not sure that Judge Higginson, this answers your question, but the U.S. Court of Appeals for the Navy Marine Corps Criminal Appeals overturned a conviction for possession of a bump stock precisely on the grounds that we are arguing that a bump stock is not a machine gun. There's no question that the use of a bump stock facilitates the ability of the shooter to manage the recoil of the weapon. The government seems to suggest that that is the automatic function that is performed, and therefore that they satisfy the automatically requirement of the statute. The fact is that a semi-automatic weapon, as its name suggests, has lots of automatic features. Among them, it will eject the cartridge that has been spent, and it will put a new cartridge in for you, and that is what allows for rapid firing. What it will not do is allow you, with a single function of the trigger, to fire more than one shot, and for that reason, it is not a machine gun.
I'm trying to make sure I understand how this works, because the brief said you put your finger on a shelf that's not the trigger to start the whole thing, right?
No, I think we just heard a concession from the government that is the trigger is the lever trigger on a semi-automatic weapon, even when you have a bump stock. The pushing forward is not the trigger, I believe the government just said. But even if it were, you would still have to pull back.
But is it the single function, the pushing forward and pulling back, and until you release that, it will continue to fire?
The government explained in its brief that it's possible to, if you push the gun all the way back inside the bump stock casing to begin, at that point, the trigger will not be in contact with anywhere near the finger, and it requires a push forward to start it. That is one way you can start the firing sequence. Nonetheless, whether you do it that way or the more traditional way of pulling back on the trigger, the government has told you today that the trigger is the lever trigger. It is not something to do with the forend of the rifle. Thank you very much.
That will conclude the arguments today. These cases are under submission. Thank you.
Okay, so now that we're through that, let's look at something. Now we got to go to, we're going to use Cornell law. And we're going to look at a couple things real quick. We ain't going to spend a whole hell of a lot of time on them because I actually do have to get a little sleep tonight. God damn it. I'm trying to squeeze these things down where I can kind of do my normal screen share and I can show both sides of this at the same time. That's not what I wanted. Where's it at? Give me just a sec, guys. I'm trying to get my act together. I'm trying to get my act together. I'm not saying it'll ever happen, but I'm trying to get it together. Da, 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 da. Okay, here we are. So this is Cornell law. This is, Cornell is a, pretty big deal in the law school arena. But see, these are the legal definitions. This is 26 U.S. Code. Let's look at machine gun. So the term machine gun. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively, or a combination of parts designed and intended for use in converting a weapon into a machine gun. That leaves a whole lot of broad fucking territory. And any combination of parts from which a machine gun can be assembled if such parts are in possession or under control of a person. That is the definition of a machine gun. That is the textual definition. And what you have to understand is the first part of this. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. That is the key to this. If the device does not function to that level, then it's not a machine gun. So auto sears, yeah, much as I hate it, they do kind of fit that definition because they do fall into that. Bump stocks, on the other hand, do not. Bump stocks are simply a firearms attachment. That's all they are. They're a piece of plastic and they slide. That's all there is to it. They don't fall into the textual definition of a machine gun. So let's see which. Here it is. So this is the actual opinion from the court, and I'm just going to hit a couple things. And oh, damn it, this isn't my highlighted copy. That's where I screwed up. This is not the highlighted copy that I had. So let me expand this out. I'm going to hit a couple things, and then I'm going to go crash. So, of course, this actually filed on January 6th. This is where everybody actually started to get this. Do I have? Hold on, I might have it here. Because right now I was just going to hit a couple of things. I wasn't planning on going, absolutely deep into it. So, So this was part of the opinion, and in the court, again, 13 judges out of 16 judges signed on to this opinion. When the ATF first considered the type of bump stocks at issue here, it understood that they were not machine guns. The ATF maintained this position for over a decade, issuing many interpretation letters to that effect to members of the public. But the ATF reversed its longstanding position in 2018, subjecting anyone who possessed a bump stock to criminal liability. So that was one thing I wanted to highlight. Let's see. They go through the Vegas shooting, deranged gunmen shooting down people. Even if that conclusion were incorrect, the rule of lenity, that's where the gray area should side on the people's case, not the government's case. The rule of lenity would still require us to interpret the statute against imposing criminal liability. So they're saying if the statute was vague or ambiguous, it would still fall to the people, not the government. A rich legal tradition supports the well-known rule that penal laws are to be construed strictly. And then they give the court case for that, which is the United States versus Wiltberger, whatever his name is. But still, again, and I've said it plenty of times on my channel already, criminal law should be interpreted very strict. There should not be a broad base for these laws. The government's going to take your life, take your freedom, and all that. There shouldn't be a broad definition of something. And then they go through that scope of criminal prohibitions. Indeed, the government would outlaw bump stocks by administrative fiat, even though the very same agency routinely interpreted the ban on machine guns as not applying to the type of bump stocks at issue here. So these are the bump stocks that don't have the spring in them, is what they're getting to there. These are just slidey plastic. And they're saying that the definition of machine gun does not apply to these. And then nor can we say the statutory definition unambiguously supports the government's interpretation. In other words, there's a strict definition of machine gun. This doesn't fit into it. You guys can go pound sand. The definition of machine gun as set forth in the National Firearms Act and Gun Control Act does not apply to bump stocks. This is the court's opinion, which reversed this whole thing. And if there were any doubts as to this conclusion, we conclude that the statutory definition is ambiguous at the very least. In other words, that statute is very well defined. It's not fucking, very broad. It sets out a very strict category. The rule of lenity, therefore, compels us to construe the to the statute in Cargill's favor. Again, rule of lenity, if there is something that's kind of ambiguous, tie goes to the runner, baby. The people are the one who get that deference, not the government. Now, we'll look at this because they go through this. The term machine gun, which we read it before, means any weapon which shoots is designed to shoot, can be readily restored to shoot, automatically more than one shot without manual reloading by a single function of the trigger. The term shall not include, or the term also includes the frame receiver of any such weapon. So if you have a receiver that's a machine gun, or actually you could put a machine gun together with it because it's got the third hole, just to leave it very, very simple, you got a machine gun. The term shall also include the frame of a receiver, any part designed or intended solely and exclusively, or combination of parts designed. God, this shit's insane. For use in converting a weapon into a machine gun, and even that is, face it, man, if you got the right amount of parts, you can take a coat hanger and make a damn machine gun. Now, you could argue it wasn't originally intended for that, but then the government's still going to put your ass in prison over it. It's how stupid this law is in the first place. Let's see, designed or intended use for converting a weapon into a machine gun and any combination of parts from which a machine gun can be assembled if such parts are in the possession or under control of a person. Now, why does that kind of piss me off? Well, if I order an AK parts kit, anybody who orders a parts kit from overseas, all right, they will cut the barrel, they will cut the receiver because those are machine gun parts. They will, however, send you the actual auto sear from the AK that is intact. So I've had to destroy a couple of them. The part that actually makes it function as a machine gun is the part they will send you intact. That is what you call constructive possession, which that whole thing about constructive possession is absolute horseshit. I either break a law or I don't break a law. That's the way that should work. Let's see. Let me run down through here. And see, this court actually gets into malfunctions like hammer follow. And if you don't know what hammer follow is, when the semi-automatic gun fires, the bolt comes back, your hammer comes back, but your hammer doesn't get trapped by the disconnector. So when your bolt goes to its most rearest position and starts to go forward, your hammer just follows it. And it doesn't hit the firing pin hard enough to strike the primer in a way that sets the primer off. It's a malfunction. You can have that with a well-worn disconnector or a well-worn hammer. I've had that in an AK that I built from a parts kit. And it only happened if I held the trigger back. If I completely let the trigger reset, then the gun ran like a champ. Nice and crisp. It was great. If I held the trigger to the rear, if I pinned the trigger after a shot, then released it and then went to pull the trigger again, I had a dead trigger because I was getting hammer follow. Hammer follow most of the time is not going to be strong enough to set the primer off and actually initiate the powder or the explosion of the powder, which expansion of hot gases, driving around down the barrel, all that. It just follows the bolt. So then mentioning hammer follow in here is quite good. It means they actually took some time to learn some of this stuff. Let's see. There were a couple of things I highlighted in here, and then I'm probably going to open it up, drink another beer, and go to bed. So this talks about the ATF in their case. But from the time the ATF considered non-mechanical bump stocks to 2017, it categorized the type of bump stock as not being a machine gun. So again, for over a decade, they said a non-mechanical bump stock. In other words, the bump stock didn't have a spring in it, didn't have any sort of aid in it. It was just a simple slidey plastic piece. The only way you can put it, telescopes. They said those were not machine guns for 10 years. And then all of a sudden, Trump, we have the Vegas shooting, and Trump, who is definitely not a constitutional scholar, basically gave them the run, or it gave them the room to run, and they banned them. So this is a response that people who were building bump stocks got back from the ATF when they submitted a sample, and the ATF looked at it, and the ATF said this is fine. So this is what they would get back if you submitted a bump stock to the ATF. Accordingly, we find the bump stock is a firearm part and not regulated as a firearm under the Gun Control Act or the National Firearms Act. So this is a response people would get when they were doing bump stocks. Hey, it's just an attachment. It's not regulated. We can't do anything about it. So we had the Vegas shooting happen, and within 10 days of the shooting, 2 bills to prohibit bump stocks or bump stock devices were proposed in Congress, and it gives the bills that were actually proposed. And the reason I hit that is because I remember those bills. But while those bills were coming up, of course, you had Trump telling the ATF, hey, you need to ban these things because, again, Trump was horrible on guns. He was great on the economy, but he sucked on guns and gun rights. He should have had people around him who would advise him and say, hey, dude, you can't do this shit. In that time where these bills came up and the ATF was doing this rulemaking, Dianne Feinstein writes the ATF. And Dianne Feinstein says this, and the reason she says this is because she's telling them that if you put this rule into place by this rulemaking that you're doing, this is going to be shot down by the courts, and it's going to kill us from being able to actually regulate this because it is a firearms park. So Dianne Feinstein says, until the day the ATF has consistently stated that bump stocks could not be banned through regulation because they do not fall under the legal definition of a machine gun. Now the department has gone about or done an about face claiming that bump stocks do fall under the legal definition of a machine gun, and it can ban them through regulations. The fact that ATF said as recently as 2017 that it lacks authority, gives the gun lobby and its allies even more reason to file a lawsuit to block the regulation, which plenty of people did file lawsuits. GOA, I think FPC was in there. They all filed lawsuits, which ended up getting shot down in the district courts. And now we see this other one in the district court, which shot down the regulation. Hopefully, a lot of these cases, or the Supreme Court, will take this eventually. But again, we're still waiting on the legal process, which people could be getting jailed over. It's ridiculous. Unbelievably, the regulation hinges on a dubious analysis claiming that bumping the trigger is not the same as pulling it, which is what their case lied on. The gun lobby and manufacturers will have a field day with this reasoning. What's more, the regulation does not ban all devices that accelerate semi-automatic weapons' rate of fire to that of a machine gun. And see, they're assuming all machine guns have the same rate of fire. There are some machine guns that are slower than others. AKs, you can have an AK without a rate reducer and it fires at a very fast rate. You can have an AK with a rate reducer, which fires at a rate that a lot of people could simulate just by pulling the trigger. Dianne Feinstein wants them to go after trigger cranks, bump stocks, hellfire triggers. She wants all that. And she's basically telling the ATF, if you do this and this gets shot down in the court, then our legislative efforts are going to be shot down also. Both Justice Department and the ATF lawyers know that the legislation is the only way to ban bump stocks, which is actually horseshit, because if you pass something that's unconstitutional, it's still unconstitutional. But Dianne Feinstein and Democrats and even Republicans don't give a damn about the Constitution. The law has not changed since 1986, and it must be amended to cover bump stocks and other dangerous devices like trigger cranks. Oh, she did mention them. Our bill does this. The regulation does not. Was there something? Hold on, let me bring that back up. Was there something else I wanted to hit tonight anyway? There's probably more stuff I'll do with this, but let's see. Okay, so we got into more of the rule of lenity. Because the statute concerns criminal penalties, the government's interpretation is not entitled to deference under Chevron. In other words, the government, since this is criminal, can't make their own definition up. They can't. The precedent for this was National Resources, yada, 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 in 1984. Cargill also argues that the final rule constitutes an unconstitutional exercise of legislative power by an administrative agency. After a one-day bench trial, the district court entered judgment for the government. One fucking day. Cargill versus Barr. That's Bob Barr. You remember him from the Trump administration, who is a complete fucking swamp rat. It declined to apply Chevron, but found the government's new interpretation of machine gun is the best reading of the relevant statute. In other words, the government can do Chevron deference. They just don't have to claim it's Chevron deference. It's just their interpretation. And then they can put people in prison over it. That's ridiculous. It's absolutely insane, actually. Let's see, let me bounce down here. I can't remember whether I did anything else after that. I don't think I did. Those were some of the biggest things I wanted to hit. And I still got to read through this. This damn thing is, 62 pages. And I've only made it past the first probably 30 pages that I've read so far. And it's just, like I said, it's freaking insane when you will let the government interpret a criminal statute. There's no way in hell the government should be able to interpret things the way that they want to interpret them. The reason we have laws is those laws set forth guidelines to where the government can act in certain cases. It's not what you can't do and what you can do. It's what the government can and can't do and when they can and can't do it. Yes, Morningstar, you're 100% right. But see, when they do this, they interpret the statute. Say the bump, not the bump stock, but the pistol brace goes through, and they arrest people over this pistol brace rule, and they put people in prison for it, or put people in jail, and it'll be a little while before they go to prison. They will go to jail first. You have people that will have their freedom and their livelihood and everything else taken away from them while they try to spend money to defend themselves against the government. And the government basically has unlimited resources. They'll just start up the fucking printing press to get more money to fuel their prosecution of somebody. So you can have someone sitting in prison or in jail for many, many years until something is overturned. And in some cases, they won't even get out then, because they will say that this law was changed from now on, but all the people that were, arrested under it before then, well, they're still fucked. Yeah, Sam, I mean, let's face it. Machine guns themselves are not banned. They're just highly regulated. And if you have the right license, you can manufacture new machine guns if you have the right license. Now, that machine gun is attached to your license, your FFL, and if you ever lose your FFL, well, then you lose the machine guns. But it's still the fact that the government should not be able to regulate these things in the first place. When we went through the 1934 NFA hearings on the channel, we went, I don't even think we finished them. We didn't. But we went through the hearings, and I had the robot reader reading the text because I didn't want to have to sit there and read the whole thing myself. These people knew, they flat out said it, that the federal government has no power to regulate firearms. Zero. That's why they use the taxing power of the government to go after machine guns. And they relied on the courts actually expanding the definition of what the government could do with interstate commerce. That's why when you read gun laws now, almost all of them mention interstate commerce, because they have no right to regulate firearms. They have the power to regulate interstate commerce. Now, the interstate commerce should only basically give the government the power to solve disputes in between states when it comes to commerce. Like if one state said, you can't bring your product through my state. You have to go around my state. And that's the quickest way for a company to transport something. Well, then you fall into the interstate commerce. Or they're deciding on prices for things and they don't agree. That was interstate commerce. But that was the only power that the government had, was to go in and they could actually go in and regulate that. I can't remember the name of the case now, and we may hit it again. It was over a farmer who grew more wheat than he had a quota to grow that year. So the courts basically said that since you were not spending money on wheat, buying it from someone else, you were negatively affecting interstate commerce. So they had the right to go in and fine him and do all the stupid shit. I'll have to look that case back up because it's been a while since I talked about that one. It's ridiculous, which all gun laws are ridiculous. And they said it in the hearings for the 1934 NFA that this would not stop criminals from doing anything. It would just give them another crime to prosecute criminals for. And they would end up trapping a whole lot of law-abiding citizens who either didn't know about the 34 NFA, weren't informed about laws. But again, we get to the long-standing legal principle: just because you're ignorant of a law doesn't make an excuse for it or for you breaking the law, which is stupid. If I don't know it's a law and I do something that breaks that law, but I still don't know it's a law, there's no intent there. I just merely did an act. And now we're getting into you owning legal products and then them going in and making those products illegal after you legally purchased them, legally used them, legally maintain all that shit. They come in later and make it them illegal, which is absolutely insane. Well, the 1934 Morningstar is an unconstitutional agency. There's nothing in there that gives the government the power to make an organization like the ATF. They got through with the being underneath the Treasury for a long time. Now they're underneath the Department of Justice. They still shouldn't exist. We have law enforcement agencies, local, and then we have some agencies federal. There shouldn't be an ATF. There shouldn't be a CIA. There shouldn't be a fucking FBI. To me, there shouldn't be a goddamn Secret Service. You know what, motherfucker? If you want to be president of the United States, how about you do a good enough job where no one wants to fucking kill your ass? And I realize it didn't work out so well for Lincoln, which Lincoln actually had the Pinkertons, I think, defending him or protecting him at the time, but still. We've gotten so far away from what is actually just in this country, just what is justice, to merely the government's offended by something, so the government gets to take your freedom and your money and everything else. It makes no sense to me. If I had 37 machine guns behind me right now, which all I've got is a stock I'm refinishing for a muzzle loader and a bunch of shotgun parts laid all over the place because I'm refinishing a bunch of stuff. But if I had machine guns back there taking up all that space, and I never hurt a single innocent person with those machine guns, there should never be a crime attached to them. I thought about doing a stream the other night on Coop's positions and then like I was running for political office. And I might do that one night just to do it. But hopefully you guys had fun tonight. Hopefully you guys learned a little bit tonight. I'm going to get out of here. It's about 1:10 where I'm at right now. So I'm going to try to get a shower, get a little bit of sleep. And I start my new schedule tomorrow, which I've got to be up every morning early, which sucks because I'm a night owl. And let's just say I don't really want to get up every morning real early anymore. So, but anyway, I'm bouncing, guys. All you perps have fun. All you perps have a good night. Hopefully, all you guys are having a good New Year starting out. And we will catch you on the next stream. I know I've missed some streams lately. I've had some stuff going on. I missed Dark stream last night, and I'm sorry about that, guys. I wanted to be there. I just couldn't. Shit happens. So all you perps have fun. All you perps have a good night. Much love for all the fam. Much love for all you guys. Be safe. Be cool. Keep that thing on you at all times. And I'm out.